How probate works in Washington when someone dies without a will. Nobody wants to think about death, much less the legal mess that can unfold when someone dies without a plan. But here's the uncomfortable truth. Everyday ordinary families in Washington state are forced to navigate a complicated, expensive, and very public court process, all because someone they loved didn't have a will in place. Maybe they thought they had more time, they didn't want to deal with lawyers, or they just didn't realize what could happen. But the statistics don't lie. Roughly 6 out of 10 Americans die without a will or any plan in place. And when that happens, even if the family is close knit, even if there's not much debt, even if there's no drama, the probate system still steps in. This means frozen accounts, months of paperwork, hefty legal fees, and a grieving family that's forced to ask a judge for permission just to access what's already theirs. So in this video, I'm going to break it down for you step by step. You'll see what really happens when someone dies without a will in Washington, how the court decides who gets what, and the emotional and financial toll it can take on the people that are left behind. Because once you understand how the process works, you'll understand why avoiding it might be the best gift you can ever leave your family. My name is Jason Gray. Me and my team at Pinnacle Estate Planning help families, homeowners, and business owners in Washington, Idaho, and South Dakota protect what they built from probate, estate taxes, Medicaid issues, and incapacity using what we believe is the most complete estate plan available. If you're watching this and you're already thinking, I probably need to get this handled, you can click the link below or go to lawpinnacle.com to book a free initial consultation. We'll help you figure out where you stand and what steps make the most sense for your family. Quick disclaimer, this video is for general educational purposes only. It's not legal advice. Every situation is different, so make sure you speak with a qualified attorney before taking any action based on what we discuss here. So what happens when you die without a will in Washington? If someone dies without a will, the legal term is intestate. This means that the state decides who inherits your property, not you. So let's say we have a man named Mike who passes away in Spokane at age 75. He's divorced. He has 3 adult children, owns a home, a car, some savings, and a few investments. He didn't have a will or any estate plan. Here's what happens next. Step 1, the funeral expenses and frozen accounts. The family scrambles to plan the funeral, and they quickly realize they can't access Mike's money. His bank accounts, investment accounts, and even his home are all frozen. Why? Because the assets were in his name only, and without a will or trust or proper beneficiary designations, nothing is going to move until the court gets involved. So the family either pays out of pocket or they try using one of his credit cards and hope it still works, which can create its own issues. Step 2, hiring a probate attorney. Once the family realizes the accounts are locked and no one's legally allowed to act, they call a probate attorney. The attorney gathers information on the assets that Mike owned, what debts are still outstanding, who the legal heirs are under Washington law. Since Mike had 3 children and no surviving spouse, Washington's intestate succession law, or the default rules, will say everything goes to the kids in equal shares. Step 3, appointing a personal representative. Because Mike didn't leave a will naming an executor, someone has to step up and ask the court to be appointed as the personal representative, Washington's term for the administrator of the estate. Usually it's one of the children, hopefully someone who's local, organized. If the other siblings agree, the person can ask to be appointed as the personal representative with non-intervention powers, meaning they can start acting without constant court approval. But if there is a conflict in the family, the process slows down fast. Step 4, court filings and estate account setup. Next, the attorney is going to file a petition to open probate in the county where Mike lived. It can take several weeks to get a court date for the judge to approve the paperwork. Once approved, the personal representative receives official documents called letters testamentary or letters of administration that authorize them to act on behalf of the estate. Finally, they can now open an estate bank account, transfer funds from frozen accounts into that new account, pay the funeral bills and other debts, start the process of selling the home, vehicle, other assets. Step 5, they're going to need to do a complete inventory of all assets, debts, taxes. The attorney is going to help prepare that inventory, listing every asset and liability, including home value, investment accounts, vehicles, personal property, credit card debts, utility bills, final income tax returns. The personal representative may also need to file a final tax return for Mike and possibly a Washington estate tax return if his estate is worth more than $3 million. Step 6, distributions to the heirs. Once the debts and the taxes are all paid, then the attorney can help prepare the final court documents asking the judge to approve the final distribution of the assets. The heirs have to sign off on that. If there's no disputes or surprises, the judge would then issue that final order. And then that order allows the personal representative to divide whatever's left among Mike's 3 children. So how long does that take? In Washington, probate can easily last 12 to 18 months or longer if there's any complexity or if there's any disputes. And even though Washington's probate system is more efficient than some other states like California or New York, it's still public, it's slow, and often very costly. Legal fees, court costs, accounting, appraisals, and filings can easily eat up 4 to 7% of the estate's value. So if Mike's home was worth $600,000, the probate fees alone, even in factoring in a mortgage of like $400,000, you might be looking at $24,000 or more in fees. So how can we avoid this? The easiest way to skip all of this is create a revocable living trust, title your major assets like your home and your accounts into the name of that trust, appoint a successor trustee who can act immediately without court approval, include powers of attorney and healthcare directives to cover incapacity. It's not just about avoiding probate, it's about giving your family privacy, peace of mind, and protection. So when someone dies without a will in Washington, the court process can take months, even years, and cost thousands in legal fees. And while the law provides a backup plan, it's not the one most people would choose. The good news is you can choose. You can create a plan that avoids probate, protects your loved ones, and gives you real peace of mind. If you want help getting started, my name is Jason Gray, and me and my team at Pinnacle Estate Planning are here to help. Just click on the link below or visit lawpinnacle.com to book a free consultation, and we'll help you figure out what makes sense for your situation. Thank you for watching, and if you found this helpful, YouTube thinks the next video you should watch is right here.